should have a bundle that is the appeal record. You should also have a bundle which is the appellants and respondents' joint authorities. I know my learned friend, Mr. Duncan, sent his up separately. Hopefully those have been incorporated into your bundle. I don't think there was a great deal of extra authority. And then finally, hopefully you should have a bundle or bundles comprising the submissions of myself and both my learned friends. So hopefully we have that out of the way. My learned friend, Mr. Horseman, raised a point in an email to me this morning, making, I thought, the helpful suggestion that given part of my submissions are that the procedure and decision or recommendation by the Board of Education was tainted, and thus too, therefore, must be the decision recommendations of the Public Service Commission. His suggestion was it makes sense for my learned friend, Mr. Duncan, to follow on from me, although that isn't the order in the parties in the proceedings. I think that makes, speaking for myself, I think that makes sense. And as a helpful suggestion would say, I suspect, save time. It's a matter, obviously, for my lord and my ladies as to how you wish to proceed. But that's, I can leave it with you at this stage. But certainly, speaking for myself, I have no problem with that.
Well, speaking for myself, that sounds fairly logical. Unless anybody else has any different view.
And for me as well, in a sense, the BOE is the primary respondent.
I concur.
Thank you. So if I can move on, and what I do not intend, I'm sure you're relieved, to plow through my written submissions. At the urging, I often say this, at the urgings of the court, I've been urged to try and hit the high notes, and I'm going to try and do that in oral submissions and leave the written submissions for your considerations. If you, I'm quite sure you've already read them, but indeed you read them again.
We have.
Yes.
I'm sorry, my lord. Obviously, yeah, make that assumption. So, my lord, obviously, in relation, if we can deal with the Board of Education issue first, as this concerns the procedure that was used by the Board of Education and ultimately the Public Service Commission in making the recommendations to His Excellency. As I should point out, it's in the submissions, that His Excellency is not a party. He has taken the position that to save costs, he has agreed to be bound by any decision of the court, and obviously the party. In any event, we can deal with the Board of Education first. This is their procedure that they used and I'm using that in a general sense, to come to the recommendations for the position of Commissioner of Education. With that in mind, can I ask ask the court to turn to the Education Act, which is in the authorities bundle at tab 9. And
there's some noise going on in the background somewhere. At least I can hear it.
I can hear it as well.
Yes, so did I.
It's rather as if somebody's working in the kitchen. I don't know who.
From Madison Thompson's connection.
Right.
I've just muted that.
It's now been muted.
Yeah.
Let's see.
Good.
We need to mute everybody except the advocates and the court. Right.
If I could,
sorry,
thank you. Just very quickly, if I could ask your lordship to look at section 4, the functions of the board, which is to make recommendations to the minister regarding the evaluation. B, make recommendations to the Public Service Commission regarding the appointment of the Commissioner of Education. Now, while we're there, if I can ask your lordships to turn back to section 3 of the Act. So this is, to some extent, important as to who shall comprise the Board of Education. And that's governed by section 3 sub 1. And we see that if A through E are various representatives of the school system. Now, it's interesting that in 3.2, section 3, subsection 2, the Commissioner of Education and a person to be chosen by the Bermuda College shall receive notices of the meeting of the board and shall be entitled to attend. So they are not members of the board having been defined in section 3 sub 1. So, for example, the affidavits of Dr. Green and Ms. Severn, both of whom are representatives, it would appear, of the Bermuda College. Although I see from my friend Mr. Duncan's submissions in the Court of Appeal, he's now asserting that Ms. Severn fell within the provisions of 3.1e. There's no evidence on that, but I'm not going to take a great point on that, my lord. If that's my friend's contention, I'm prepared to obviously accept it. But let me deal with that, because we did deal with the issue of the composition. Let me make this point, that even with assuming the Severn was an appointment of the board pursuant to 3 sub 1e, she in any event had no Bermuda public school experience since 1995. That is set out in her affidavit. If you want to see it, it's set at tab 8, paragraph 5 in the appeal of the record bundle, which she says, in 1986, I commenced my career in the field of education as a music teacher in the Bermuda public school system and remained for 8 years. In 1995, I moved to the United States. So that was her last involvement in the Bermuda public school system. So whether or not she was a member of the Board of Education, and given my friend's position, I'm going to accept that she was. By no stretch of the imagination could she be taken, having not had any Bermuda public school experience since for essentially 25 years. It hardly been, in our respectful submission, properly able or qualified to interview a person for the position of the Commissioner of Education. Alternatively, as we say, quite frankly, given that she was a Bermuda College appointee, she is not a member of the Board of Education in any event. The other member of the Board of Education who sat on the interview panel was Mr. Wilson, who I suspect.
Before you go on, Mr. Diel,
I'm sorry, my lord.
so you take issue with her statement at paragraph 4 of her affidavit. Then you say that that is simply wrong.
Well, my lord, she says I've been a board member since December 2016. Now she doesn't say exactly how she becomes a board member, but my friend, as I say, my friend in his submission says she's a board member by virtue of section 3.1e. I'm not going to quarrel with that. It's in my friend's submissions.
Right.
I don't think, my point on that, Lord, is I don't think we need to get bogged down in the niceties of whether or not she was actually a board member or not. In any event, because she could have been, just by way of analogy, she could have been seconded onto a properly appointed committee of the board, assuming she had the qualifications or experience to interview. That was nothing to stop her from doing that. My point on this is to say, in any event, it matters not, because she had no public education experience since 1990 in Bermuda, since 1995. My point on that, Lord, is to say, this is an overview of the entire appeal, is was this entire process fair? And in my respect, when you look at it in the round, we say resoundingly, it was not a fair process. And this is one example of where the process was fatally flawed, and clearly on the authority, on the evidence, has been fatally flawed for it would appear, decades. In any event, so the interesting point on the fact that there was no public school experience was dealt with, interestingly, up at tab 9 by Dr. Green, who is the ex officio member of for the Bermuda College, and says that she has sat on a number of these panels. And if I can ask your lordships to turn to paragraph 9, tab 9. And she makes this point, this is at the bottom of the page, 3 lines from the bottom. One question related to the fact that no one from the Bermuda public school system was included on the interview panel. I interjected and confirmed that I had served on all previous interview panels, and there were no other educators on the previous panels. So if I can put it this way, the excuse for there being, and the acceptance in the evidence that there was no one from the Bermuda public school system on the panel was quite simply to say, well, this is basically, and I'm being slightly flippant, but this is the way we've always done it. And you will see by way of example, there is Dr. Green, who is not a member by definition of the Board of Education, saying, well, I had sat on these previous interview panels and we've always done it this way. And she is not a member of the Board of Education. Now, the point I'm making is that this, hopefully making, is that this is a systemic, it seems to be a systemic problem. In any event, what happened was, as your lordships know from my submissions and hopefully from the evidence, that there were a number of applications made, both Bermudian and non-Bermudian. And somewhat surprisingly, what happened was the permanent secretary and the representatives from human resources took it upon themselves to go, to go through the applicants and exclude, in any event, all the non-Bermudians, and then include 2 candidates, the 2 Bermuda candidates, one of which was my client and the other was Ms. Richards. And they were shortlisted. Now they were shortlisted, obviously, or they say, on the basis of the recruitment code. And our position, quite simply, in relation to the recruitment code, is that it just doesn't work in this case. This case is designed, this situation is designed for the specific situation where you have a Commissioner of Education. The Commissioner, appointment of Commissioner of Education. The Commissioner of Education is, by definition, under the Act, the head of his department. So if we can turn to the actual recruitment code itself, which is at tab 10, it's exhibited to the affidavit of Trott. And if I can give you some hopefully some examples. And if we can start, for example, at page 4, paragraph 3.0, second paragraph of that. The Department of Human Resources, together with the relevant permanent secretary and the relevant head of department, are responsible for ensuring that the principles of the recruitment process are followed. Well, given that this is a position for the head of department, and there was no head of department, this doesn't apply. That is why it is the Board of Education, in this case of appointment of a Commissioner of Education, that is tasked with the job of making the recommendations to the PSC, not an interview panel, which occurs in numerous other situations. This is not one of those situations. And then if we can go, for example, to page 7 of the recruitment code, selection of interview panel. The DRM selects the interview panel members in accordance with 9.4.
Sorry, where are we now?
I'm sorry, my lord, we're at page 7 of
Of the-
the recruitment code.
Of the code, yes.
Paragraphs, yes, sorry, my lord, that is at tab 10.
Yes, I am with you.
I'm sorry, my lord. It's very unusual because usually I can follow what your lordships are doing in court, but I can't see. But I'm looking at 7.4.
Yes, selection of interview panel.
Indeed, my lord, yes. The DRM, that stands for Designated Recruitment Manager, selects the interview panel members in accordance with 9.4 of this code. The panel is chaired by the DRM, and for present purposes, my lord, the DRM in this case was Ms.
Trott.
Trott, yes.
Yeah.
Ms. Trott. So she should have been supposedly the chair. That didn't happen in this case because Mr. Wilson was the chair. And the DRM leads the recruitment and selection process. Then if we go over the page to 8.0, which is under the heading of shortlisting. The applicants are shortlisted based on the minimum education and experience requirement of the established post as outlined in the official job description. We're just pausing there. One asks the question, how does this mesh then with the Public Services Commission's obligation or duty to consider all applicants? If you've excluded a chunk of the applicants before you even get there, and in this case, not only did they exclude the applicants based on minimum education and experience requirement, they excluded applicants simply because they were non-Bermudian. Now, again, I'm not saying that my friends make the point that, oh, well, what are you complaining about? Because it got the pool got narrowed down from 9 applicants to 2. My point on this is to show that this entire process is simply wrong, and the process has been systemically wrong, and is, if I may say, using the recruitment code in this fashion, in my respect for Commission, demonstrably wrong. Then over to page 10. (9.4). The interview panel is typically comprised of no less than 3 individuals. Only the designated recruitment manager has to be certified in recruitment and selection. One panelist must be an independent assessor from outside of the employing department, and the remaining panelist should be the direct line manager. Well, again, we have the Commissioner of Education is the head of his department. So there's a live issue as to who is the quote direct line management. Of course, in this process does not even require or mandate anyone from the Board of Education being on that panel. Government employees, sorry, I'll go down to.
Before you go on, it doesn't mandate that the panel has to be 3. In this case, it was 5, wasn't it?
My lord, yes, it was 5 in this case. I'm going to take you, just when I finish going through this, I'm going to take you to the Schedule 1 of the Employment Act, which shows how a panel or a committee of the Board of Education should be set up.
Yes. And do you take any issue with the assertion that the direct line manager here was the PS herself?
Well, my lord, now I'm going to accept that arguably she is the direct line manager in the sense that she was head of the ministry, but the Commissioner of Education, as I've already said, is head of the department. But we'll go to the Education Act in any event shortly. If we can go down 2 paragraphs. Where the vacancy requires a specific technical skill or qualification, then one panel should possess the specific skills or qualification in order to assist in making an effective technical evaluation. Here, in this case, as I've already said, well, there were none. Given that the best that this panel could offer as far as a Board of Education representative was one who had 20 years experience in the area of the public school system some 25 years ago. But again, this we'll see clashes with, in my respectful submission, with the provisions of the Schedule 1 of the Employment Act.
Education.
Then if we can go just to paragraph 10 at page 12. Once the interview has been completed, the appropriate head of department, well, in this case, as I've already said, the position is for the head of department, forwards the recommendation letter to the HRM or HRO for review and submission to either the Public Service Commission, for those posts that require His Excellency the Governor's approval, or the Director of Human Resources. Well, it doesn't even, in our case, what happened was it was forwarded to the Board of Education. So this doesn't even contemplate a situation of forwarding it to the Board of Education. It doesn't mention it, it doesn't consider it. And there's a reason for that. And the reason is because there's already provision made in the Education Act for the procedure to be used. So if we can turn now to the Education Act, or back to the Education Act, which is tab 9 of the authorities bundle. And ask your lordships to turn to page 46. Sorry, and my lady, of course, I apologize.
I'm so sorry, tab 9.
Sorry, tab 9, my lord, of the authorities bundle, page
Yes.
46.
Mr. Diel, you needn't refer to me separately.
I'm sorry.
Just lump me in as
I'm very grateful, my lady. Thank you.
and your
I-
ladyship every
I
time.
don't mean anything sexist by it. I apologize.
No, just call me whatever, but your lordship is fine.
I don't think you should call me my lady. It might be misunderstood.
I'll do my best, my lord. Can I ask you to turn to page 46? And we're looking. This is the schedule Schedule 1 to the Education Act, and we're looking at section 12. The board may appoint a committee for any of the purposes of the board and delegate any of its functions to such committee with or without restrictions or conditions. Obviously, in this case, as we've already seen, the duty of the board is to make recommendations to the PSC. Obviously, also one of those, for example, for fairness, would be to actually interview, for example, interview the applicants. Or alternatively, a committee could have been formed to actually make its recommendations by way of the smaller committee of the board directly to the PSC. Now,
Of course, emphasis is placed on the words "and delegate."
yes, my lord. Well, yes. Well, I would say, my lord, it's also any of the purposes of the board.
Yes.
So it could be, for example,
What is said here is that they did not delegate the recommendation.
they didn't, my lord. That is firstly, that's my complaint. That the Board of Education didn't delegate anything. What they did essentially was to abrogate. They relied entirely upon these recommendations made by a panel, an interview panel, which had no statutory basis, was improperly constituted. Because what, if we can just go, sorry, my lord, I'll come back to your point, but if we can go back to section 12, because what it does is it sets up a fair and proper procedure for any of its purposes to be, for example, interviewing or in turn making recommendations to be accomplished. So that it says the number of members of the committee shall be fixed. And obviously one of its members shall be chairman. And then paragraph 4, sub 4, a committee appointed under this paragraph may include persons who are not members of the board, but the chairman and at least 1/2 of the other members of every committee must be members of the board. So in the present case, the composition was through the interview panel comprised of 3 civil servants, 1 representative of the board of the Bermuda College, who had not any public school service experience since 1995, and Mr. Wilson. And again, no disrespect to Mr. Wilson. Mr. Wilson was an appointee. He is a lawyer, as some of you, certainly some of the court may know, and he was appointed pursuant to section 3(1)(d). 2 persons, which is 2 persons appointed after consultation with organizations representing the business community as determined by the minister. So he wasn't, and again, no criticism of Mr. Wilson. He simply is not an educator.
I mean,
That was your interview panel.
yeah, I mean, yes, if you look at section 12, if it's applied, it plainly wasn't fulfilled because the board didn't appoint the interview panel. It didn't a fortiori fix the number of members or their term of office. It didn't appoint one of its members to be chairman of the committee, although one of its members was in fact chairman of the committee, and it didn't include at least 1/2 of the other members as members of the board.
My lord, yes.
If this applies, each and every subparagraph was not followed.
My lord, yes.
Indeed, the board's submissions are that it didn't purport to apply Schedule 1, Section 12, but it chose instead to adopt the recruitment code procedure as required.
And that's my point, my lord. It chose, instead of doing its duty which is in the proper duty of making recommendations, must obviously be to perform its own inquiries. It had the process within which to do it. Section 12 sets out the process. As I said, for example, if they wanted to set up a committee to interview the applicants and then to make recommendations themselves to the main board, they could have done so. They could even have set up a committee to bypass the entire board itself and simply make recommendations directly to the PSC, provided they fulfilled the requirements of Section 12 of Schedule 1 of the Act. That would be perfectly all right.
No, the latter would be delegation, properly so called.
My Lord, yes, that's right. And my Lord is absolutely correct. But and in this case, there wasn't delegation. And that's Mr. Wilson in his affidavit is quite candid about that. He says we didn't appoint, we had nothing to do with the appointment of the interview panel. I can take your lordship to that if you like.
This is although he chaired it, eh?
Sorry, my Lord?
This is although he chaired it.
Yes, my Lord. Well, he says. He was, sorry, I'm jumping around a little bit, but he was the two persons who were involved in the composition of the interview panel were the permanent secretary and the representative, Ms. Trott from HR. The evidence is that they themselves appointed this committee. They say they did it in accordance with the recruitment code. The point I'm making is you can go through the recruitment code and see it doesn't work in the present circumstances. Far less, for example, the composition of who should be on the panel, because it clashes with Schedule 1, Section 12. So he says, perhaps I can just, there's some important comments that he makes in his affidavit. Tab 13 of the appeal record is Mr. Wilson's affidavit.
Yes.
And this is what he says. As previously stated in paragraph 3 above, I was a member of the panel. I was a member of a panel that interviewed applicants for the position of the Commissioner of Education in March of 2016. I can confirm that as with this current competition, none of the candidates that made it to the interview phase of the 2016 competition were interviewed directly by the board. I can confirm that as with this current competition, the board did not appoint an interview panel to act as its agents for the interview phase of the competition. I do not perceive that the Education Act contemplates this function to be the role of the board as a whole. And he says the board is empowered by Section 4(1)(b) of the Act to make recommendations. The Act does not set out the method by which the board should obtain information that it will consider in making its recommendation. Further, the board as a body does not have the financial or administrative resources to post job advertisements, collect resumes, shortlist candidates, etc. There must be an administrative support body to support this process. Additionally, the post of Commissioner of Education is a civil service post, and the recruitment of the holder must be performed in alignment with the recruitment code of the Public Service and PSC regulations. And you will see that attitude reflected in the minutes of the meeting, where the board were told by the civil service that they must adhere to the recruitment process that was set out, i.e. the recruitment code. And Mr. Wilson is, in my respectful submission, completely wrong. Firstly, certainly in this paragraph, certainly because he ignores completely, doesn't even mention Schedule 1, Section 12, because it does set out a method by which the board can obtain information. And in this case, obviously, a fundamental aspect of fairness in considering someone for a job application is to interview those people. And his second point is, and this really is not a reason, but not an excuse. He simply says we don't have the administrative financial wherewithal to do this. Well, that unfortunately is not a reason to ignore, or in this case, bypass the provisions of Schedule 1.
Is your argument that had they properly followed the recruitment code, that process would have been acceptable?
No, my lord, because as I've said, you will, on going through the recruitment code, in a number of aspects, it just doesn't work.
Yes.
My learned friend, Mr. Duncan, makes the point in his submissions, and to an extent, I know this is shocking, I actually agree with him in this aspect.
Oh, do be careful.
He makes the point saying, well, I said in this aspect, my lord, he says, and I'm paraphrasing, but he says in essence, if there'd be nothing wrong with the Board of Education comprising a committee under Section 12 of Schedule 1, and then using the recruitment code. I would to that extent agree with him, because by that stage you had taken out the issue, for example, of the composition of the panel. But of course, you couldn't use the provision that says that you have to send your recommendations on to certain people. That you could only use the recruitment code where it fits. Now, if we can actually, while I'm on this point, if we could go to, oh, excuse me, sorry, I do apologize. I'm sorry, I can't turn this thing off. If we can go to the minutes of the meeting of, I'm sorry, my lord. I'm trying to disconnect this thing. Sorry, if we can go to the minutes of the meeting, which is in the affidavit of this Trott, which is a tab, there's a couple of affidavits, so second affidavit at tab
15.
Tab 15, yes, thank you. And the minutes are, I think they're the first one, there are a few pages in into the exhibits.
GT2.
Yes.
Page 3 to page 6.
And if I can pick it up, it's actually the first page of the minutes of the board. First page of the minutes of the board, which is, it's got the number 3 at the bottom right-hand corner.
Yes.
Yes.
So there's a couple of points here that I need to deal with. The chair opened the meeting by referring to an email sent to the board members to advise of a directive from the Minister of Education to convene an urgent special meeting of the Board of Education. Pausing there, it is in the evidence, so I can take you to it if necessary. There was supposed to have been a board meeting on the 9th of August. That meeting was cancelled due to there not being a quorum, and a fresh date was set for the 10th of September. The minister of Education was obviously unhappy with that, because he wanted this issue of the Commission of Education recommendations done and dusted as soon as possible, and obviously by the beginning of the school year. So he sent a letter to the board to say, get on with this, and the 10th is not good enough, have an urgent meeting for this specific purpose. So that's what this is about. He shared the purpose of the meeting was to discuss the process undertaken for the recruitment of a Commission of Education and to consider the recommendation of the interview panel. And then he invited Ms. Trott in the department to guide the board through the recruitment process. Ms. Trott introduced the process by sharing that the government recruitment code was developed by the Department of Human Resources and must be followed by all managers and supervisors when recruiting for vacant posts. Then goes through the process, which is in accordance with the recruitment code. As I've already hopefully pointed out, it clashes in a number of fundamental areas with what is supposed to happen in the appointment of the Commission of Education. For example, I've dealt with the composition, so I don't need to trouble your lordships with that.
May I interrupt here, Mr. Diel, before you go on?
I'm sorry, my lord.
Yes, may I pose this question before you proceed?
Of course.
In the passage you just read,
Yes.
where it says he shared the purpose of the meeting was to discuss the process undertaken
Yes.
for the recruitment of the Commission of Education.
Yes.
Now, this is being presented to the board itself.
Yes, my lord.
Putting aside the question for the moment, whether that process complied either with the Act or the recruitment code,
Yes.
is it not at least an implicit acceptance by the board itself of the process which had been undertaken?
Yes,
on its
Lord.
behalf?
I would say in that sense, well, I would say where the board subsequently says we're going to go with the recommendation of the interview panel, I would say that is an implicit. I would have to say, and I think you can't get away from the fact that the board implicitly accepted the process. The fact of the matter is, my lord, is that they can't do that because
Yes, I understand that
yes,
point.
but I would agree with my lord in the limited scope of my lord's question. It is, and it has to be. In fact, I think it's later on they go with the panel's recommendation. But my point on that is, well, your lordship has my caveats already. Your lordship mentioned it.
Mr. Diel, would you forgive me a moment? When I can see your face as I can now, I can hear. No, when I can see your face as I can now, I can hear you much better.
Oh.
When I see the side of your face, the thing, there's a sort of pinging noise, and occasionally it's a little difficult to follow. I don't know where you are in relation to whatever picks up your voice.
I'll try and do that. I'll try and face the screen full on, my lord.
Yes, thank you.
Sorry, yeah. If I can ask you, if that's better, my lord, if I can ask
Yes,
you,
it is.
thank you. If I can ask your lordships to turn to page 5 of the exhibit. This is where this is a section where board members, quite rightly, and I would say almost instinctively, raise concerns as to the process. The permanent, it is about 2/3 down the page, the paragraph that starts, the permanent secretary spoke to concerns expressed by board members. Sorry, I should go back one up, my lord. Board members asked the following questions. How many candidates applied for the position? Were the non-Bermudians qualified for the position? Were there non-Bermudian spouses of Bermudians who applied? Why weren't the non-Bermudians interviewed? Did the non-Bermudians have any connection to Bermuda at all? And then the last one was a quorum issue. So there was already at this stage concern as to, well, wait a minute, if we're supposed to be making recommendations to the Board of to the Public Service Commission, we should have had and should have been party to this type of process. Why weren't, it was a very valid question, why weren't non-Bermudians who were qualified, presumably, interviewed? And that goes again as to the duty of the Public Service Commission to consider all the applicants. In the present case, obviously the Board of Education didn't consider all the applicants, and in fact is accepted, and I'll take your lordships to it, it is accepted that the Public Service Commission didn't consider all the applicants. So then going back to where the permanent secretary spoke to concerns expressed by board members in the process not being shared with them prior to the interview, and provided a timeline, which basically it shows that we're literally running out of time. The PS also shared that as the line manager, she's held accountable to ensure the post is recruited for within a time frame. There was the challenge of timing as the school year was coming to an end, and there was no movement in the recruitment of the post. Therefore, the interviews were undertaken mid-July to keep the process moving, with the intent to present the details of the recruitment process to the board at its 26th of July meeting. However, this meeting was later cancelled due to no quorum. So what had happened was the PS seems to indicate that we used this process because we were running out of time. Then it goes on, additional questions were raised and discussed that included, how was the interview panel selected? Why didn't the interview panel consist of board members who worked in the Department of Education? Were all the questions answered? Why wasn't there a meet and greet? That's obviously with the board members. Why was it satisfactory to interview only the qualified Bermudians and not the qualified non-Bermudians? So then then we went on. If I can drop down, yes, the Bermuda College ex officio member, that's Dr. Green, advised she was asked to serve on the interview panel, but declined due to having a close relationship to one of the candidates. Then the representative from the business community, that's Mr. Wilson, thanked the senior human resource manager and the permanent secretary for presenting the recruitment process and answering questions. He asked, this interesting comment, he asked the board move forward with the right spirit and respect the official recruitment process that had been followed. So it was with that tenor that the Board of Education, having been told that this is the process that you have to use, and despite all their, as I say, almost sort of instinctive concerns, because they were asking these questions that any proper board member wanting to interview and wanting to make a proper determination would ask. And had the process dealt with under Section 12 of Schedule 1, this wouldn't have arisen. Then strangely, the acting chair, Mr. Wilson, I'm carrying on reading, stated the board was under no pressure other than what the board is determined to do under the Education Act. Well, that's a rather surprising statement, given what the PS had just finished stating, the section I read out at the bottom of page 5 over to page 6, i.e. we've got to get on with this, and the urgings of the minister in his letter saying that, you know, you've got to get on and do this, and the 10th of September is just no good. He then asked members if they were willing to put forward their recommendation to the interview panel for the COE post. Board members verbally confirmed their willingness. The acting chair asked the permanent secretary to read the board the recommendation of the appointment. The function of the board as read as per the Act was stating that Ms. Richards be recommended to the PSC for the appointment. So that is the context within which the Board of Education were faced with this decision. So to simply state in the affidavits, oh, we were happy with the process. Firstly, they were told that that is the process they had to be happy with. So whether their happiness is irrelevant. You'll notice that there's no discussion there at all about why we didn't have a subcommittee to deal with this. One suspects, doubtless, because the answer will be twofold. One, this is the way we've always done it. And secondly, we don't have the facilities to deal with this process. And I would say deal with this process properly. Sorry, I just catch up with my notes. So just hopefully I'm saving time. Yes, just perhaps the final point on tab 13. Sorry, if I could ask your lordship to go back to tab 13, paragraphs, yes, 16 and 7, yes, paragraph 16. Sorry, my lord, I should have covered this beforehand. I didn't. Paragraph, this is Mr. Wilson's affidavit. Again, I dealt with paragraph 17. After the board's examination of the findings of the recruitment panel, I asked the board whether they were prepared to consider the conclusion of the recruitment panel, or whether they wanted to stop the process and commence a different method of obtaining information in order to equip themselves to make a recommendation to the Public Service Commission. Well, if we just been through the minutes where the civil service and the permanent secretary had just finished telling the board, wrongly in my respectful submission, that the procedure they had to adopt was the official recruitment process. And there was no discussion, for example, by say, well, we should have examined, we can form our own committee. Neither was it practical at that stage, given the minister's urgings that this matter had to have been done and dusted by the beginning of the school year.
Mr. Diel, are we raising an issue of fact here?
Which fact, my lord?
Well, whether or not there was indeed that discussion of which Mr.
Well, we can see there wasn't, my lord, because it's not in the minutes.
Well, that's why I interrupted, because there is that line in the minutes about adopting the spirit, proceeding in the right spirit.
Yes, and using the
that
official...
suggests there's some discussion about the process.
And using well, you have to look at it in context with, if you look at
page 6 of the minutes.
Yes, my lord. If you look at firstly, my lord, page 3 of the minutes, where this is Miss Trott, the HR, government HR. And I've read it before, but perhaps she introduced the process by sharing the government's recruitment code was developed by the Department of Human and must be followed by all managers and supervisors when recruiting for vacant posts. So she is saying you have to use this process. And so you look at that.
But you also quite properly highlighted the passage above.
Yes.
Where Mr. Wilson, as a chair, shared the purpose of the meeting was to discuss the process.
Yes. Right.
And to consider the recommendation. So that does suggest that there was indeed discussion of the process undertaken.
Well, yes, my lord, but the process was, as was determined by the statement by over at page 6, which your lordship was referring to, and respect the official recruitment process that had been followed,
Yes.
i.e. the mandatory process that you need to do. I mean, you know, basically replace official with mandatory. That's look at, and you look at page 3, my lord. It's my respectful mission, crystal clear. The Board of Education are being told we went through the correct procedure. This is the procedure. Here's the answer, and you guys may the board may accept or reject this recommendation. So in those circumstances where not one single member of the Board of Education that had any experience in the Department of Education, hence the question at the top of page 6, second bullet point, why didn't the panel consist of board members who worked in the Department of Education? It would be respectfully self-evident that if you're going to interview someone who's going to head up the public school system, the people who actually work in the Department of Education and are board members be part of that panel or committee. Basically, what instinctively, it's quite interesting, what the Board of Education were looking to see is amazing. Why didn't we use a process that, in fact, they didn't seem to know this, was already set out in Schedule 1 of the Education Act? Why did the permanent secretary and HR have 3 civil servants, 1 lawyer, and 1 person from the Department of Education, from Bermuda College, to determine or make a recommendation as to who should be or should head up the Department of Education?
Of course, the permanent secretary herself has the requisite experience, doesn't she?
She's not a board member. Yep, she's not a board member.
But so far as the constitution of the panel itself was concerned,
yes,
she would have had that technical skill.
She had some experience, my lord. Yes, but when you look at the entire process that was done, part of our complaint, as you can see, is that there's an issue. We've obviously raised the issue of bias, and this entire process was, for want of a better phrase, hijacked by the permanent secretary. Firstly, she was the one who shortlisted the
Yes,
applicants.
I didn't mean to interrupt. I know you come to the arguments about bias, but I'm just for the moment focusing on the.
But yes, strictly on that point, my lord, she has some experience in. She has some experience in the public service. She is, because she's the permanent secretary. She has worked in the Department of Education, but she's not a board member. And if they had thought that the permanent secretary would be a useful addition to this process, it could have been an easy matter to set this out in Schedule 1 or in the Act itself. And in any event, the political process, if I can put it that way, or political, the ability of the government to have its say in relation to who is appointed is dealt with both in the Public Service Commission regulations, and it is also covered where the Premier has the ability to have his own say in relation to the governor when making the appointment. So that aspect is already dealt with. That is why, in this case, you have the concept is that the experts in the field of education, in the field of public education, make recommendations to the PSC. That is the purpose of the education of section 4. That's why it's there. And what has happened in this case is that the entire process has been sidestepped by appointing a panel who has no experience in this area, with the possible exception of the Permanent Secretary, who shouldn't be involved in this process anyway, because there's no mention of her being involved in this process. The recruitment code, which, as I've already said, is not the appropriate procedure to use. Otherwise, because if you look at it if there's any credence to be given to this procedure, what it's going to have the effect of is rendering section 12 of the Act, of the schedule, completely pointless. And in essence, renders section 4, the relevant section where you make recommendations, where the board makes recommendations to the PSC, effectively pointless. Because what you can do under these is to appoint an interview panel in accordance with the code, make recommendations, and that's the end of it. Why have those sections there? They must serve a purpose. And and unfortunately, my respectful submission as a learned judge at first instance, he held there was nothing, in his view, wrong with this process. It renders those sections pointless, or potentially pointless. They can simply be sidestepped. Yes, and then here's, if we can go to tab 14, please, my lords. This is the affidavit of Mr. Dickinson, former chairman of the Board of Education. And if I can ask your lordships to turn to paragraph 13. For the sake of this, it says, I'm sorry, do your lordships have that?
Yes.
For the sake of clarity, it should be understood that in the absence of an administrative mechanism for undertaking full recruitments, the board uses the government's recruitment process for hiring civil servants and the HR services of the Department of Education. So that is saying, if that is actually a tacit admission that they should have used the right process, and saying because we simply don't have the administrative wherewithal to do it properly, and of course I'm putting my own spin on it, but this is how, this is a fair reading. In the absence of that, the government uses this recruitment process.
You mean the board?
Well, in this case, yeah, the board. The board uses the government's recruitment. It's not what the Act makes provision for. I think if we can go back to tab, I'm just trying to make these points together. Well, if we can go back to tab 10. Yes, this is Ms. Trott's affidavit at paragraph 9. The board is required to make recommendations to the PSC regarding the appointment of the Commissioner of Education in accordance with the Education Act. However, the board does not have its own administrative resources for the purposes of conducting employment competitions, and so relies on the resources of the Department of Education for that purpose, along with the participation of members of the Board of Education on the recruitment panel. Also, the appointment of the post Commissioner of Education is a public service appointment. Thus, the process should align with the recruitment code and the PSC Commission regulations. No, that is why Section 4 exists. That is why in the recruitment code, there is no mention of an interview panel making recommendations to the Board of Education.
Is it right that, leaving aside the recruitment code, that the process would have to align with the Public Service Commission regulations?
I would think it would, my lord, yes, because in order for example, well, to some extent, my lord, perhaps, because your lordship, it's in my written submissions, but for example, the PSC have their own ability, for example, to conduct interviews. So they can do, so if, for example, there wasn't all the applicants, or the PSC thought, here's a possibly viable applicant, but they, for some reason that applicant hasn't been interviewed, they can go ahead and interview. So there is provision to allow the PSC to plug the gaps if they need to. My point on when we get to the PSC is to say, given that, in fact, basically abrogation that existed in this case, the PSC had firstly the obligation to consider all applicants. They didn't do that. And then secondly, and in any event, because Ms. Richards lacked the minimum academic or professional qualifications, they had the obligation then, if they were going to select her, to make a determination, their own determination, that she was of sufficient merit, I think the wording of the regulation is, notwithstanding her inability, notwithstanding her failure to meet the minimum academic qualifications. I'll come to that in shortly. They didn't do that either. What they did was they literally took the letter of recommendation from the permanent secretary, because when you actually look at it, it's actually the letter to the PSC is not actually from the Board of Education, it's actually from the permanent secretary, but took her letter and, for want of a better phrase, rubber stamped it and passed it on to the governor. But they actually did a cut and paste job of part of her letter, and we'll come to that in due course. But they certainly didn't. There is, sorry, taking a long way of getting around to answer my lord's question. In the round, yes, they should comply with the requirements of the PSC in order to properly make a proper recommendation. But in circumstances where there's been that failure, the PSC has the ability to do its own investigations and should have done so in this case.
If I might, Mr. Diel, following on my Lord President's question, assuming the acceptability of the interview panel, does that then indicate your acceptance that the winnowing process of eliminating non-Bermudian candidates would have been in compliance with the PSC regulations, the requirements of the, you say it's not?
It's not, my lord, no. It's not in compliance. That's part of my complaint, is to say, and that's why I was saying right at the very beginning of my submission, this is an example of this sort of systemic failure where you automatically, this had nothing to do with the Board of Education. The field was narrowed from, I think it was about 9, I'll stand corrected by my letter, friend.
Purportedly in compliance with the PSC regulations,
Well,
as I understand Ms. Trott's evidence.
no, I don't think it was, my lord. I don't think, to be fair, Ms. Trott said, I think it was more, if I may say, more of a political decision because they wanted they wanted a Bermudian for the position, and that's why they excluded. I don't wish to overstate the evidence, but I think, to be fair, that's the purpose of it. And what my friend,
They do so purportedly in compliance with the regulations.
I'm sorry, my lord, where are you reading from? I don't think it was in. I don't think it doesn't say, my lord, in the recruitment code that you, for example, you automatically exclude non-Bermudians.
But it does in the public service regulations, doesn't it?
Well, my lord, that's, I don't, again, wish to get bogged down in that, because what it says in the public, they're not well worded, because that obviously contrasts with the duty to consider all applicants. And it also says, my lord.
Yes, but wait a moment. I mean, be it assumed for the moment that there's a duty to consider all applicants. If the applicants whom you didn't consider were people whom it would not have been lawful to appoint in the first place, the fact that you didn't consider them really goes nowhere, does it?
No, my lord. No, my lord. What it's a duty. How it works, how it should work, is that the Board of Education considers all applicants and makes a recommendation to the PSC. I can make a recommendation saying we prefer, or our recommendation is Mr. X, who may happen to be non-Bermudian. Now, what the PSC is then fixed with is a decision whether to. They couldn't accept that recommendation because under the regulations, they're not actually allowed to make a recommendation to the governor where that recommendation is going to be non-Bermudian. It's rather confusing. So if they're unable, if they say, well, yes, we think Mr. X is clearly the best candidate, and there's no one else to recommend, we will make no recommendations. Then it goes up to the governor to have the input of the premier as to who should make the appointment. It clashes, my lord, the duty to consider all applicants clashes clearly with this the directive also of saying you cannot make a recommendation of non-Bermudians. It doesn't alter the fact, and I don't want to get, as I say, I don't want to get bogged down in it, but it doesn't alter the fact that firstly they have to consider all applicants, and it doesn't alter the fact that that the Board of Education, in making its recommendation, must also, if a fortiori, consider all applicants.
But wait a moment, I don't want to get too far down, but I mean, this is a point of criticism that you make, and you appear to be suggesting that the board firstly has to consider all applicants. It could decide to recommend somebody whom it would not be lawful to appoint.
No, my lord. No,
well, if that's
just ask your lordship to be careful. It's not a question of lawful to appoint. We've had non-Bermudian commissioners of education in the past, so it's not a question of it might be unlawful or ultra vires for the Public Service Commission to make a recommendation of a non-Bermudian to the governor, because one of the regulations says you shall not make you shall not make recommendations for non-Bermudians.
Yeah,
that's not an appointment issue. That's a recommendation issue.
But wait a moment. Okay, I think you're accepting that it would not be lawful to recommend a non-Bermudian.
Yes, in which case they make no recommendations whatsoever. Let us say that the only qualified. Let's make the.
Wait a minute. Why do you say in that case they make no recommendation?
Well, they can't.
Well, wait a minute. They can't recommend a non-Bermudian. But
Yes,
if they have 2 non-Bermudians whom they can't recommend and 3 whom they can obviously recommend the Bermudian.
yes, my lord, but they still have the obligation to consider all applicants.
Okay, but I mean, where does that take one? They recommend a Bermudian. They could not have recommended a non-Bermudian. You say that they have an obligation to consider all applicants. Any consideration of all applicants would inevitably lead them to the position that they couldn't recommend the non-Bermudians. So
Yes.
if they didn't consider the non-Bermudians, so what? Had they done so, they couldn't have recommended them anyway.
My lord, yes, in which case I was going to say, let me take an obvious example. Let us have a situation where the only qualified applicants for the position are non-Bermudian. So in
Well, you
which
can take
case,
that example if you like, but it's not this case.
I accept that, my lord. And as I said, right at the beginning, I didn't wish to get bogged down on this particular point. I was merely using it as an example of the systemic problems that are inherent in the procedure that is currently being used, where at the very beginning, non-Bermudians are automatically excluded from the entire process. That cannot
In that
be.
regard,
Sorry.
I understand the respondent's position to be that you shouldn't elide the consideration process with the shortlisting process, because the entire list of candidates was put before both the board itself and before the PSC.
Yeah.
Although the shortlisting process had resulted in only the 2 Bermudian candidates
Let us.
being interviewed.
Yes, my lord. Can I ask your lordship on that point to go to tab 6? Because you have to look at the affidavit. It's credit to my learned friends. It's the 2 affidavits are carefully worded. Oh, the second affidavit is carefully worded. If we can go to tab 6, this is the affidavit of Ms. O'Brien, who's the secretary to the Public Service Commission. And if I can ask your lordship to turn to page paragraph 7.
Yes.
I understand that one of the complaints made by Dr. Tucker is that the PSC did not consider all of the applicants. While it is true the PSC did not receive and review all 7 applicants, I can confirm the PSC did consider Dr. Tucker along with Mrs. Richards for the post. What they're saying is only Dr. Tucker and Mrs. Richards were confirmed for the post. What happened later on, one suspects they saw the problem that had arisen, and they at tab 17, there was this affidavit, a second affidavit sworn by Ms. O'Brien, to quote, to use her words, clarify, where she says, as indicated, this is paragraph 2, as indicated by Jermaine Trott, the PSC was provided with the applicant summary form, which listed all the applicants, which showed out of the 7 applicants in total, 3 were non-Bermudian and 2 did not meet the qualifications. I can confirm that PSC did receive the applicant summary form and noted, aside from Dr. Tucker, as the unfiled applicants were either non-Bermudian or not qualified. The PSC then went on to consider the 2 full applications of Dr. Tucker and Mrs. So the simple fact of the matter is, all that was sent was the summary forms, and it doesn't detract from Ms. O'Brien's first affidavit, where she quite clearly says the only people who were considered by the PSC for the position was Ms. Richards and Dr. Tucker. It doesn't alter the fact that the PSC did not consider all of the applicants for the position.
Yeah, but what further consideration ought there to have been if the other applicants were either non-Bermudian or not qualified for the post?
Well, again, my lord, if you have qualified non-Bermudians, the purpose of the Board of Education, the Education Act, is for them to make recommendations to the PSC of the best applicant, irrespective of whether that applicant is Bermudian or non-Bermudian. It doesn't say anywhere in the Act or the legislation or anything to do with the Board of Education that you shall automatically exclude from consideration all non-Bermudians. If that's the case, my lord, no, there would never ever be a non-Bermudian Commissioner of Education.
Yes, but that is not this case at all, is it? There's no suggestion here that there was some non-Bermudian who was better suited than either Dr. Tucker or.
I accept that, my lord, but
successful
I
candidate.
said before, I've simply said this is demonstrative of the systemic problems that exist in the process, where you, for example, automatically exclude qualified non-Bermudians for the position, which is just it's fundamentally wrong. In which this is our education we're talking about of our youth. Whether the governor decides to appoint the best person upon the considerations or having discussed it with the premier doesn't detract from the matter. That is the appointment. You cannot simply at the first level simply discard qualified applications, particularly given the duty, express duty on the Public Service Commission to consider all the applicants. I accept it clashes with the provision that talks about Bermudians and non-Bermudians, but which one prevails? I've said it's not elegantly worded. Those are the provisions as they exist. And it certainly doesn't stop the Board of Education from having the duty to recommend the best applicant. That didn't happen here. Well, that's not fair. We don't know who the best applicants are.
I know you don't seem to become bogged down at this point, nor do we, but just so we can perhaps complete the discussion, is it accepted that the PSC itself could have started the process over, having seen the entire list?
Yes.
If it had not been satisfied with the process?
Yes, they could have done. And that is part of the complaint. That's what they should have done. But we know that there's a matter of practicality they couldn't have done, because this happened in mid to late August with a directive from the minister to get on and make this decision on the appointment or recommendation of the Commissioner of Education, because it was to be done and dusted by the beginning of the school year. As a matter of practicality, how is this board in a matter of days to redo the process? The simple fact of the matter is they could not. And given that at the time the board were being told by HR and by the permanent secretary that this is the official recruitment process, that is the end of the matter as far as they were concerned. Now, if we can actually turn to the letters of, so what happened at the end of the Board of Education meeting was that the permanent secretary volunteered to write the letter of recommendation to the PSC. And if we could turn to that, that is at tab, sorry, I've lost my place.
Tab 11?
It's tab 16, my lord.
16.
Yes, yes, there's the two letters. It's the affidavit. We got this on discovery.
Oh, yes.
So this is the second affidavit of Dr. Tucker.
Yes.
And if we can look at the letter from, it's on Ministry of Education and Workforce Development letterhead. It's signed by the permanent secretary. I write to seek approval of the appointment of Ms. Richard, a Bermudian, for the above mentioned position in the Department of Education, and it sets out the advertisement. 7 applications were received. 2 were shortlisted and invited to be interviewed, and the interview panel comprised, and it's set out. Then it went through the interview process.
May I ask Mr. Diel, is there any issue that this was indeed written on behalf of the board?
I'm going to accept, although it's actually I think she actually makes the the last. I'll merely make this point, my lord. It's interesting that the last, if you turn to page 4 of the letter, the very last 2 lines, the panel recommends her appointments to the commissioner, to the post of Commissioner of Education. I support the recommendation of the panel. Well, she was a member of the panel. It must say, on reading this, you would be given the impression that she was writing on behalf of the panel and not the Board of Education. I think it's just perhaps not the most. I'm certainly going to accept, for present purposes, that this was written for and on behalf of the Board of Education, despite what the rather inelegant or inaccurate wording. Can I ask your lordships to turn to, and perhaps I should put it in to where it says summary. Therefore, they go through the entire process where I think my phrase is, she speaks glowingly of Ms. Richards and does a bit of a hatchet job on Dr. Tucker. And then summarizes, therefore, the consensus of the interview panel was that Ms. Richards is the most suitable and best candidate for the post, as she demonstrated having the required knowledge, broad educational work experience, and strategic leadership skills. Meeting held on the 14th of August, the acting board chair presented the panel's conclusion, which states the function of the board, etc. Unanimous vote of the board in support. Then, although Ms. Richards has a professional qualification in an education discipline, the minimum relevant and senior management level experience required for the post, she does not possess a master's degree in educational administration, as per the official job description, which was last reviewed in 2014. Therefore, Ms. Richards is being recommended for the post in accordance with Regulation 18.2 of the PS regulations and Section 2D of the guidance for appointment, which reads, in addition to those applicants who meet the full requirements of the approved job description, the hiring manager, in consultation with the head of department, well, that's the Commissioner of Education, may request that applicants be shortlisted if they do not meet the minimum education requirement, but possess at least 2 additional years of relevant experience above the minimum education requirement, as outlined. Well, obviously, again, this is an indication of where the procedure that they were using doesn't work, because here you're talking about a head of department may request that applicants be shortlisted. That didn't happen. The Commissioner of Education, under the Act, is the head of department, not the permanent secretary and not the member of HR. Then they go on, in any event, she goes on, the approved job description seeks 15 years relevant experience, including 10 years experience at the senior management level. Ms. Richards has 35 years relevant experience, with 23 years experience at the senior management level, and they say accordingly recommend her appointment. Now, just pausing there, that section which I've read out to your lordships has absolutely nothing to do with the issue of ability. It's all to do with experience. And this is, if you turn the page, this is what the PSC, who have a duty in this case to consider, given, as I said earlier, given her not having the minimum academic qualifications, if nevertheless she has the requisite abilities. And this is how they dealt with it. PSC would like to recommend, so this is dated, I should make a point, 30th of August. So this was sent on the 17th. So within the, trying desperately to meet the timelines, the PSC fire off a letter to the governor.
This is where?
Oh, I'm sorry, but it follows straight on. It was still at tab 16.
Right. Yes, thank you.
Thank you. Sorry, Lord. So the PSC would like to recommend the appointment of Ms. Richards to the post. And it points out that post holder must possess a degree or equivalent. In addition, a minimum of 15 years relevant experience, including 10 years experience at senior management level, is required for the post. Ms. Richards possesses a master's degree in management and human resource development, etc. She has 35 years experience as an educator, including over 20 years at senior management level. That's experience, that's fine. The Commission agreed to recommend Ms. Richards in accordance with the PSC regulations 18(1)A and section 2 and 2D of the guidance for appointments, which states, in addition to those applicants, I mean, you've already read that, they set out the same provision. But interestingly enough, having cited section 18(1)A, there's no determination, and we can go to section 18(1)A of the regulation, which are at tab 8 of the authority, sorry, tab 8 of the authorities finder. See what they say. So section 18(1) says, subject to these regulations, the qualifications or relevant experience or both. Now, pausing there, so they're talking about qualifications as one issue and experience as another, or both. For any office shall be those for the time being specified by the head of the civil service for that office. And the Commission shall recommend for appointment thereto a person who possesses such qualifications or relevant experience or both. So that's the starting point. Then 1A says, notwithstanding paragraph 1, the Commission may recommend for appointment a person who does not possess either the qualifications or relevant experience or both, if the Commission is satisfied that the person is of sufficient merit to enable it to make the recommendation. The Commission did not consider properly or at all the issue of Ms. Richards' merit. They considered only the issue of her experience, to say that she's got all this experience, therefore the fact that she doesn't have the minimum academic qualifications that makes her fit for the post. That is not what 1A says. Neither did.
What of 1 itself, sub 1 itself, because it's disjunctive, isn't it? Such qualifications or
experience
or both.
Well, she lacked the minimum. She lacked the minimum qualifications, academic qualification. So therefore, under 1A, they could recommend her for appointment if they're satisfied that she is of sufficient merit.
No, I'm talking about relevant experience.
Yes, my lord.
And that's under 1 itself.
Yes, my lord. But then 1A, because then you had, they obviously saw the problem. That's why 1A, section 1 was sort of qualified.
I see.
I say, well, what happens if you have someone who doesn't either meet the minimum qualifications or has the requisite qualifications but not enough experience? You can still make a recommendation if despite that, this is what 1A is saying, if despite that, those shortcomings, sorry, I don't mean that in the pejorative, they can, the person nevertheless is of sufficient merit.
Yes. And the letter
So,
does
where
cite,
you have a candidate, I'm sorry, my lord.
and the letter does cite 1A.
It cites 1A, my lord, but then what it does is, all it refers to above is her experience. That's the paragraph above. And then they only set out the guidance for appointments, which is the issue of experience. Again, that is I made the comments earlier. That is the cut and paste job that the PSC did in relation to the letter of recommendation signed by Ms. James, the one just preceding it. That letter also doesn't deal with, well, in fact, she actually gets the section wrong, but she doesn't deal, she also just sets out the issue of experience.
Mr. Diel, isn't it implicit in the decision, or could it be said against you, that it's implicit in the decision that they must have considered merit?
I would say no, milady, no. They would have to consider, firstly, the Board of Education simply has the duty to make a recommendation for the best candidate. There's no evidence at all in the minutes, for example, that anybody ever considered the fact that was she nevertheless of sufficient merit. If that was the case, milady, then you wouldn't need to, the simple fact you just make the recommendation would obviate the need. The reason you have to, the PSC has to, in these circumstances, where it's received a recommendation of someone who doesn't have that merit, has to embark upon its own exercise of determining whether or not that person is of sufficient merit. You can't, with respect to them, you can imply it simply by the fact that because the Board of Education made a recommendation, their QED, this person is of sufficient merit because she lacks the relevant qualification. In fact, I think it's slightly worse than that, because if you go to the minutes, again.
Give me the tab number.
I'm sorry, I'm looking for it myself. It's at tab 15, my lady.
Thank you.
If you can, I don't propose to read through them, but I ask you perhaps on this point, your ladyship is obviously free to skim through them. But there's no...
It's that minute, is it?
I'm sorry, my lady?
The 14th of August, 18.
Yes.
Yes.
What page would you like us to look at?
No, well, I'm merely making the point that here are the minutes, and there's no discussion here about the fact that she lacks the minimum qualifications. That arises only in the letter from Ms. James to the PSC. So if there was no discussion...
It is not strictly correct to say she lacked the minimum qualifications. There's a distinction between the technical educational requirements and qualifications.
I'm sorry, but I didn't mean it I didn't mean to be in that sense. I'm using, I'll use the wording from Ms. James's letter. Although Ms. Richards has a professional qualification in education discipline and the minimum relevant and senior management level experience required, she does not possess a master's degree in education administration as per the official job description.
Yes.
So what it says is, I don't think there's any, it must possess at least a master's degree in education experience. So for example, if you have a doctorate in it, that's obviously sufficient. Now that's what I'm, sorry, that's what I meant by minimum. I didn't, so she didn't meet the qualifications And there's
But
no
just a
discussion.
moment, going back to what my lady was saying a moment ago, the quote problem, unquote, was that Mrs. Richards did not possess the relevant qualification because she didn't have a master's degree in the right thing. So
Yes.
that was the position that the Public Service Commission had to consider.
Yes.
Regulation 18(1)(a)
Yes.
says that the Commission may recommend a person who doesn't possess the qualifications, which is what we are presently concerned with,
Yes.
if the Commission is satisfied that the person is of sufficient merit to enable it to make the recommendations.
Yes.
What the Public Service Commission is saying in this letter is, A, she doesn't have the requisite qualifications.
Agreed.
That appears in
Yes.
paragraphs 1, 2, 3, and 4. But then that the Commission agreed to recommend her in accordance with 18(1)(a), just pausing there, that is a regulation that applies if the candidate does not possess the qualifications.
Yes.
But the
Or
Commission,
relevant experience.
well, yes, but yes, all
He has the
relevant.
relevant experience.
He has the relevant experience. 18(1)(a) applies that the Commission may recommend somebody who doesn't possess the qualifications if satisfied that the person is of sufficient merit.
Yes.
When therefore the Commission says that it agreed to recommend her, firstly, in accordance with the Public Service Commission Regulation 1A, the only potential relevance of 1A is that it can be relied on in relation to somebody who A, does not possess the relevant qualification, but B,
Christopher.
I've lost your lordship.
then go on in addition to refer to section 2 and section 2D of the guidance, which has an additional provision that the applicant can be shortlisted if he doesn't meet the minimum education requirement, but possesses at least 2 additional years of relevant experience.
Yes.
So effectively what they're saying is she didn't have the relevant experience. I'm so sorry, she didn't have the relevant qualification, but we were satisfied in accordance with regulation 18(1)(a) that didn't matter because she had the necessary merit. And we were satisfied in relation to section 2D of the guidance for appointments, if that is relevant, that she possessed at least 2 additional years of relevant experience, although she did not meet the minimum education requirement.
Well, yes, but that's my criticism, is that they managed to come to that conclusion when that issue was never even ever considered by the Board of Education.
Well, it was only considered by the Public Service Commission.
Well, yes, my lord, but they didn't do anything extra other than what was sent to them by the Board of Education.
Yeah, but what was said to them by the Board of Education in the letter that was sent to the Public Service Commission must obviously have made plain to the Public Service Commission that she was of sufficient merit that they should take this course.
But my lord, that's why I took you back to the minutes.
I know.
Because there was no discussion in the minutes of the issue of her lacking the requisite qualifications and being nevertheless of sufficient merit. So if the board of, given that the PSC conducted no independent exercise review itself, it relied solely on the recommendation of the Board of Education. And given the Board of Education did not turn their minds to the issue of her being of sufficient merit simply because, of sufficient merit because she lacked the requisite qualifications, there was nothing with which the PSC could properly have come to the conclusion that she was nevertheless of sufficient merit. The issue had never been considered properly or at all. And that is why, my lord,
you say that, I take it, because it is not expressly set out in the minutes?
yes, my lord, it's not set out in the
That is why, this is why I asked you about the letter written by the permanent secretary, because that letter does address it.
Yes, my lord, that's
If
the
it's written
first
on
time.
behalf- If it's written on behalf of the board,
Yes, my lord.
that suggests that it was a factor.
And that's the first time that it appears. It clearly wasn't discussed by the board. It clearly wasn't. And so this is what you have. This is the problem that you have when you have a permanent secretary who insinuates herself through every single step of these proceedings and creates in a letter, yes, and I will accept for the purposes of this hearing that it was written on behalf of the board. Issues arise in this letter which were clearly never discussed. There's nothing in the affidavits of Mr. Wilson. There's nothing in the affidavits of Ms. Green, or nothing in any of the affidavits to say that because she possessed the minimum qualifications, we nevertheless thought she was of sufficient merit. What they did was they did, at least on this basis, make the recommendation for the best candidate. It doesn't mean that the best candidate is of sufficient merit to be accepted by the PSC. There are different issues arising there. And the PSC, and that is why I have the Jamaicans for Justice case, where in that case, the Privy Council held, oh, sorry, sorry, Mr. Duncan, you can't hear me? Mr. Duncan, okay. All right, sorry, Lords, can I just wait until Mr. Duncan comes back on, or you can hear me? Mr. Duncan's waiting.
He can't hear you.
He's lost.
Can't hear.
That may be a good thing. Sorry.
We can hear you. Perhaps somebody should call Mr. Duncan to find out whether there may be a problem at his end.
Yeah, because I can hear you, Mark.
Sorry, I don't have his number.
I'll call the
If
firm.
you could, yes. Sorry.
Email him.
Delroy, you still can't hear me? Sorry, excuse the informality. Richard, can you email Delroy?
Yeah, I just emailed him and said it must be a problem on his end because we can all hear you.
Mr. Quayle is trying to get him by phone as well.
Can you hear everyone? You can't hear anyone.
I think he's going to answer the phone.
Mr. Vasquez has suggested that you reboot your system. Yeah. Okay. All right. Okay. Shall I stay on until you sort it out? Yeah, I tell you what, I'm going to put you on speaker here, mute your mic, and then once I hear you back in, I'll disconnect this call. Okay? Yeah. Okay, you can continue. They'll just listen in by the court teleconference.
Mr. Duncan can hear us, can he?
Yeah, can you hear us, Mr. Hawthorne?
I can only hear you on the phone.
And can you all hear him on the teleconference?
Yeah,
Yes.
We can continue that way, and then they'll join us back on here.
I think before Mr. Duncan was frantically waving, we were, I think my Lord President was making the point on the issue of merit. And if I could just hopefully summarize, the fact, given that the PSC did not consider the matter independently, they didn't have an interview process, they didn't do anything other than accept the recommendation of the BO, of the Board of Education. And given that the Board of Education did not consider, because they didn't have to under their act, the issue of her having the requisite merit in spite of the fact that she lacked the requisite qualifications, you can't infer that because they simply went with the recommendations and they cited 18.1a, that they were nevertheless of the view that she had the requisite merit, because that is exactly why the Jamaicans for Justice case, that issue, having seen this, the fact that she lacked the requisite qualifications, and that there was no, and as we now know, there was no consideration of the issue of her merit, the PSC ought to have engaged in its own exercise of making that decision. They ought to have conducted their own inquiries. That is basically what Jamaicans for Justice, my friends try and distinguish it by saying the court at first instance tried to distinguish it by saying it was unique. It's facts. The facts are irrelevant. Right? What the case concerns, or the principle of the case, is where the PSC are under a duty or have the ability to conduct further inquiries, whether they're put on notice that they should be conducting their inquiries. In essence, Lady Hale in that case was saying they're under an obligation to conduct those inquiries for basic principles of fairness. That didn't happen here.
What do we make of the fact that Mrs. Richards had been acting as commissioner for some 6 months?
Yes.
And that should have been known both to the members of the board and the PSC. Yes.
But that doesn't mean perhaps you can take judicial notice, my lord, that simply because someone has been a civil servant in a position for any period of time doesn't automatically equate to having the requisite merit.
No, I wouldn't
to do that. And it doesn't obviate from the PSC the duty, and I would say in this case the duty, to conduct its own inquiries, because it is an obligation that is on the PSC specifically. It doesn't exist in relation to the BO, the Board of Education. So the PSC has this obligation. So where they are faced with an issue of someone who doesn't have the requisite qualifications, they're the ones that have to make the determination independently that that person possesses the requisite merit. It was clearly it was never considered, and the fact that it's crept into the permanent secretary's letter to the PSC doesn't advance the matter. In fact, it's another example of how unfair this system, how unfair this entire procedure was to Dr. Tucker.
Did the Board of Education know that she didn't have the requisite educational qualification?
It certainly doesn't appear to have been mentioned at all, my lord. That's my point. Because it's not in Mr. Wilson's. I stand to be corrected, but by either of my friends, it's certainly not in the. It's certainly not in the minutes. I don't recall seeing anything of it in Mr. Wilson's affidavit. He would be the most obvious person to talk about it, as he was the chairman of the interview panel and also sat on the Board of Education.
And you say it is inserted into the permanent secretary's letter without having been brought to the attention of the board.
Now,
Yes. Yes, yeah. And given that, you know, they set out all the questions and the issues, and
What do you
nowhere
make
is
in
there.
that regard at page 6 of the minutes or of the exhibit?
Yes.
The minutes begin at page 3 and so that's tab 15. What do you say we ought to make of the last sentence of the third paragraph from the end?
It's chilly.
I'm sorry, some terrible gurgling noises are going on somewhere.
Yes.
I'm sorry, I'm struggling to hear your lordship.
Some terrible
Yes,
gurgling noises are going on somewhere.
Yeah, it looked like somebody just joined the meeting, but I think.
Can we mute them?
If I could just interject, Lord President, for the members of the gallery, this audio is being streamed live on YouTube. You'll see in the group chat that there is a link to the YouTube recording so that you could leave this forum and join on that forum. I'd ask that you please take advantage of that.
Yes, I was
sorry,
Mr. Diel's attention to page 6.
Yes, my lord.
The last sentence of the penultimate paragraph. It reads, the acting chair asks the permanent secretary to read to the board the recommendation for the appointment of the COE. What ought we to make of that?
Oh, sorry, the acting chair asks the permanent secretary to read to the board the recommendation. Yes. That was.
Does that bear in relationship to the letter that would have been sent to the?
No, my lord. That was the recommendation made by the interview panel to the Board of Education. And in fact,
do we know whether that discusses a question of qualification?
Well, I don't think so, my lord, because if you look at the next paragraph, where they set out the function of the board, section 4.1b, that would have been a good time for there to have been discussion on the fact that she didn't meet the minimum qualifications. It's just, again, I stand to be corrected by either of my friends, but certainly I can't find any reference to the issue of lacking the minimum qualification.
Well, just a moment. Can we go back to tab 10 in the bundle, page 19?
Of the exhibits, my lord?
Yes. This is the applicant summary form.
Yes, my lord.
Which, as I understand it, was before the board.
Yes. Yes.
And it's got 3 non-Bermudians who aren't shortlisted, somebody who isn't shortlisted because he or she doesn't meet the qualifications, and then we get yes, shortlisted, extensive years of relevant experience, then A, not shortlisted, and A, yes, shortlisted, meets qualifications, which looks as if it's a statement that A was shortlisted and does meet the qualifications. Well, sorry, the last A was shortlisted and met the qualifications. The pre-penultimate A was shortlisted but didn't meet the qualifications.
But has extensive years. Yes, that, my lord, absolutely, my lord. That, if we can go, if we can go back to The easiest place to find it is probably in one of the letters, doesn't matter which. If I can ask your lordships just to hold your finger there and go back to tab 16. And for example, the letter of, it doesn't matter, they're both of the 30th of August letter to the PSC. That deals, the issue of experience deals with sections 2 and 2D of the guidance for appointments, and also, my lord, I should say, also deals with, now that I think of it, the reason for shortlisting, and that is in the best place in the code of recruitment code. We can go to Miss Trott's affidavit in the exhibits. That is why that is in there, my lord, because if you can go to, sorry, just yes, it is, sorry, we actually, right, I'm trying to find where there's I think it's actually in Miss Trott's affidavit where she points out that you can have
Yeah, paragraph 15 of her affidavit.
I'm grateful to my friend, sorry. Yeah, Dr. Tucker was one of the shortlisted, yes. I'm grateful to my friend, thank you. Was one of the shortlisted. It was noted that Miss Richards, the other short, did not possess the minimum academic qualification. However, in accordance with the guidance for appointments as prepared by the Department of Human Resources, she was sufficiently qualified to be shortlisted for interview. A true copy of the guidance for appointments is that. And further, sections 16 and 18 of PSC permits the PSC to recommend for appointments individuals who do not possess the qualifications or relevant experience, or both, as may be specified by the head of the civil service, if the person is of sufficient merit. Yes, that is why she was shortlisted, because she had the requisite experience. It doesn't, once again, there's a distinction, and that is why I took your lordships to 18(1)(a). There's a distinction between obviously qualification and experience and merit. As I've said in my written submissions, a person may be of significant experience and lack the requisite merit. The chart that my Lord President was referring to simply is a reason as to why they were shortlisted. Yes, shortlisted because of extensive years of relevant experience. That is the reason for their shortlisting, not, and it doesn't deal with the issue of merit.
But wait a minute. Sorry, isn't that unreal, isn't it? Of course, the summary form doesn't deal with the issue of merit, but the summary form tells the board that there are two candidates, one of whom does possess the relevant qualifications, the other of whom doesn't possess the relevant qualifications, but has extensive years of relevant experience. They then decide by a strong majority to recommend the one who doesn't have the relevant qualifications, but does have extensive years of experience, and whose merit they must have thought was manifest, hence their recommendation.
No, my lord, that is, with respect, I would, respectfully disagree.
Well, I know, but why not?
Because that is not their duty. Their duty is to make a recommendation for the best candidate. It is for the PSC to determine independently whether that person is of sufficient merit or not. And
well, wait a minute, their duty is to determine the best candidate. They decide that the best candidate is a person who, although she does not possess the specified qualifications, has a lot of experience, and is the best one looking at the overall merits. That's
Indeed.
what.
As to what really happened, I think one might look at the affidavit of the chairman, acting chairman, Mr. Wilson,
Yes.
at tab 13, paragraphs 14 and 15, at least as he saw it from the point of view of the person chairing the meeting.
Oh.
So it's tab 13, paragraphs 14 and 15.
Yes. Yes.
And at 15, he says, next at my invitation, Mrs. Trott discussed the relative merits of the candidates, a reference to the findings of the recruitment panel after the interview. So clearly the question of the relative merits was there being considered by the board itself at the invitation of the acting chairman.
No, well, in relation, my lord, as they say, to who is the best suited candidate, i.e., who would we make? It doesn't address the issue of the fact that because she lacks the requisite qualification, she nevertheless is of sufficient merit to.
Yes, it does.
It's never
Yes, it
discussed.
does. But it must address it. If you know that somebody doesn't possess the relevant qualification, but that she is manifestly better than the other person, you are deciding that her merits outweigh the fact that she doesn't possess the relevant qualification.
With respect, my lord, no, because if that was the case, then that would be the obligation of the Board of Education under the Act as well. It is not. It's specific to the Public Service Commission.
Wait a moment. I know that the obligation is specific to the Public Service Commission, but let's take things in stages. If one asks, what did the board do? It obviously determined that despite the fact that Miss Richards did not, by a short margin, possess the relevant qualification, namely her merits were such that notwithstanding, she should be recommended to the post.
My lord. Well,
That
is not. I'm sorry.
Sorry, what were you about to say?
No, I'm just saying. I'm simply saying that is as. Sorry, I would respectfully disagree with my Lord President. What they did was they examined the quote merits of both candidates and decided this candidate versus this candidate, this was the better suited candidate. They did not consider the issue of nevertheless, this candidate is still of sufficient merit to warrant the post, because that was not within their purview.
They must have considered she was of sufficient merit to warrant the post, because that was what they recommended. Well,
their obligation, my lord, was to make recommendations to the best candidate.
Yes.
That is all.
Yes.
They didn't. Because that is why, my lord, independently of the Board of Education's obligations, the PSC has that extra obligation to consider whether someone doesn't meet minimum qualifications. The Board of Education does not have that obligation.
I know you've said that several times, but when I say take it in stages, I mean what I say.
Yeah.
If one asks what was it that the Board of Education did, it seems to me as at present manifest that they considered that the best candidate on the merits was Miss Richards, despite the fact that she didn't possess the relevant qualification. Forget whether it was their duty to do that. That is what they did.
Well, my lord, if they may have considered, maybe we're getting mixed up to some extent in phraseology, but they may have decided that on the merits, she was the better of the two candidates. But that is a distinct and separate thing from the duty of the PSC. And I'll leave it there.
Right. Well,
I can see my Lord President is not with me. I'm
telling you my concerns in order that you have the opportunity to address them.
No, I'm grateful. As always, my Lord, I'm grateful to some extent.
To some extent, yes. Okay. Well, let's get on.
Well, I will fall back in any event, my Lord. I'd fall back on the simple point that it matters not as in relation to the to how the Board of Education came to that conclusion because it was based on a recommendation from, and I've already dealt with this, from an interview panel. And your lordship has my points on that.
Yes, we got that.
Thank you. So on that basis alone, I would say, given that the fact that the interview panel was fundamentally flawed in its composition and authority to act and so on. So QED was the Board of Education, their Applicants for Justice case, in the exercise of determining for themselves, A, who was the best candidate, and B, irrespective of that, having arrived at the decision of who made the best, did that candidate nevertheless, lacking the requisite minimum qualifications, still have the ability or the merit to do the job. And perhaps I should go to if I can. I'm looking at the time. My lords, can I merely do on the Jamaicans for Justice case for your lordship?
Yes.
Can I deal with it this way?
Yeah.
It's a tab 12. I don't, unless your lordship specifically want me to take you to it, I've hopefully summarized it as to the principles. And could I ask your lordships in particular just to read paragraph 2 and paragraphs 23 to 28.
Certainly.
That sets out the obligation, as I call it an obligation, that the Privy Council held that the Court of Appeal got bogged down in the issue of duty over obligation, and they held, despite the fact that it was a quote, a power versus a duty, and the Court of Privy Council held that despite the wording that it was a power, in those circumstances, which involved concerns raised about the unfortunate, highly relevant at the moment, and unfortunate issues of police officers, police officers dealing with brutality, etc., that the PSC in that case ought to have conducted its own inquiry, and we are in that same situation here.
Yes, thank you. Right.
Sorry, so I was. Yeah. And then also, my lord, the BTC. Sorry, my lord. The BTC and telco case.
Mm-hmm.
Well, that issue, sorry, that is.
Could I have the tab number, please?
Yes, I'm sorry, my lady. I'm just looking at it myself. I'm working from a different
Tab 13 of the
tab
authority.
13, my lady.
Thank you.
Tab 13, I'm sorry.
Thank you.
That case concerned the issue of inquiries or investigations made by the minister, with the Department of Commission of the Telecommunications Commission. And there were two issues really in there. One was whether the commission was properly comprised of the requisite number of experts, which the court held that it wasn't. But in addition, the issue of, because what had happened was there was a series of hearings of which, as it transpired, only 2 members of the entire commission actually sat through all of those hearings, and it was dealt with on the, as Mr. Beloff QC argued, it was dealt with on the basis of whether or not the he who decides, if I've called it he who decides must hear. And perhaps if we can go to, there's a number of judgments in this, but if I can go to the judgment of, I think it was Mr. George's. Yeah,
I see
that's-
you were
that's-
in the case, Mr. Diel.
Yes, one of those, I was, my lady, yes.
Always good to refer to one's own case.
Well, I was going to make the very, yes, it is. I was going to make the very tongue-in-cheek comment that this must be good authority because it's cited in Supperstone. But of course, that chapter is edited by Mr. Beloff, who also is not, he's
Yes,
so keen to cite his own victories.
one tends to say one's own triumphs represent the true law.
Well, I wish. My lord.
So Justice George's judgment, you
Mr.
say?
George's judgment,
Mr. Lord?
Lord, page 14 at the top right corner.
Yes,
I'm sorry, I don't need to trouble you with that aspect. Sorry. 18 and 19.
thank you.
Yes, it was towards the bottom, my lord. It was contended on behalf of Telco that there had been a breach of natural justice and that members who had not heard the evidence had participated in the decision making. I do not understand the Solicitor General to dispute the principle that members of the Commission who were fully apprised of all the evidence should not participate in making the decision. Rather, he submits that on the record, it cannot be concluded that there was a breach of the principle. Deliberations had taken place, the details of which had not been recorded in the minutes. In the course of these deliberations, information available to each commissioner could have been shared by all. The fact that the proper procedure by way of judicial review had not been followed and precluded the filing of affidavits which could have clarified this issue. I do not find this approach satisfactory. The principle that a decision maker should have available for consideration all the facts and submissions put forward by a party to the dispute is crucial. The records of the Commission should make that clear. They do not. It would not be necessary that every member of the Commission should attend every meeting. The full notes, though not necessarily debated in the Commission, taken at each meeting, should have been taken and circulated. So doubtless, well, in fact, the comment has been made by my friends as well, that's exactly what happened here. But the more important fact of the matter is, and this is where, in my respectful submission, and due respect to my friends, they missed the point, is that what happened in that case was that the Commission itself embarked upon the investigation. That is exactly what should have happened in this case. The Board of Education should have appointed its own committee, properly comprised, conducted its, either have, as I've said earlier, have conducted the entire investigation and made recommendations to the PSC, or have been appointed simply for the purpose of conducting the interviews and making recommendations back to the Board of Education. They did neither. Consequently, there's not the point of he who decides must hear hasn't not been adhered to in this case. And then finally, the issue of the reckless decision, which is at tab 18.
Not tab 18,
Sorry,
tab 2.
sorry, Richard.
I think it's tab 2, isn't it?
Tab 2, sorry, I don't know why I've got tab 18 down there.
Sorry, tab 1.
Oh, sorry, in fact, the relevant extract, if we can, sorry, what I was doing was using the judgment of the learned judge at first instance. If we can go to actually tab 18 of the record, which is the judgment. I do wish to make some comments in any event about the judgment.
Yes.
I'm sorry.
I'm sorry, my lord, I'm jumping, it's my fault. The appeal
That
record.
first instance here, is that it?
Sorry, first instance judgment, my lord, yes, tab 18 of the appeal record.
Thank you.
So it was just easier to go there as I was planning to go to the judgment anyway.
Mhm.
And at page 12 of the judgment, yes, paragraph 31, he says, apart from the specific provisions set out in paragraph 9 above, The Education Act does not lay out a prescribed procedure for the Board of Education's role in the appointment of the Commissioner of Education. In my respectful submission, yes, it does, where they're going to be relying on extrinsic evidence, or in this case, someone to do their interviews for them. They have the procedure. The respondents rely upon the English Court of Appeal case in Reckless, and then this is what the learned judge cites from the judgment. He says the regulations do not purport to prescribe the means by which the members are to investigate the matter. Pausing right there, Lord. It does. They can either do it by way of the whole board doing it, or they can ascribe some or part of it to a committee. For example, there is no specific requirement for any of them to interview any of the candidates, nor is the manner of voting. Well, my lord, where you are talking about candidates for a position of Commissioner of Education, it is self-evident that one of the fundamental issues has got to be interviewing the candidates. And that is tacit from the questions asked by the Board of Education themselves, and the fact that the interview panel themselves obviously interviewed the candidates. In the absence of any prescribed rules, the procedure is a matter for them. Well, here in this case, my lord, we have a procedure that is set out where the board wants to have a committee do it for them. So all that is necessary that goes on in law is that that it should be fair and be reasonably adapted for the purpose of providing the members with the material necessary to make an informed decision as between the candidates on the statutory shortlist and enabling them to reach what could be properly termed as a collective decision. Well, that is precisely what Schedule 1, Section 12 does. It sets out a fair process for the purposes of providing members with the material necessary to make an informed decision. There is no reason why, as part of that process, they should not ask a smaller group of members to assemble the information to conduct interviews for the purpose. Absolutely, my lord, there is the procedure. He goes on, that is not a delegation of their statutory function. It is, in this case, we do have it, as my Lord Smelly pointed out, it specifically refers to delegation in that section. It is simply an exercise of their implied power to take steps to obtain the information necessary to perform it. In the present case, you have an express power to take the steps necessary to obtain the information to perform it. So where you have an express power, it would become a legal nonsense, in my respectful submission, if you could say, oh, well, there's an implied power, and the implied power means we can do anything, no matter what Section 12 of Schedule 1 says. So with respect, the reckless authority does not assist my learned friends, and the learned judge at first instance was wrong to rely upon it. And then the learned judge goes off in paragraph 34, for example, on talking about improper delegation of the Public Service Commission's function in relying on the interview panel's report. Well, that with the greatest respect to the learned judge, that it's wrong on. First of all, the Public Service Commission don't have any ability to delegate in this manner. What he, I think, meant was there's no improper delegation of the Board of Education's function in relying on it. But in any event, in the present case, there was, as Mr. Wilson has said, there was no delegation. This was done without their input at all, without the board's input. That's the problem. If there had been delegation, it could have been done and should have been done in accordance with the Act. Paragraph 36 Dr. Tucker's third case, Jamaicans for Justice, turns on its unique facts and does not assist. With respect, it doesn't turn on its unique facts. It is simply an example, as I've already said, of where the Public Service Commission has, where it has a power to make inquiries, it becomes, issues of fairness and proper procedure becomes in essence an obligation. Yes, and Lady Harold, on behalf of the Board of the Privy Council, that such an investigation ought to have been carried out. We say we rely on that case and say that is the situation here. Based on the reasoning in Reckless and Dolding, I'll go back to Dolding, I find the interview panel process used in the Board of Education consideration and recommendation of Ms. Richards to the post of commissioner did not constitute an improper delegation of the board's function. But again, this is somewhat confusing because it is accepted by Mr. Wilson, and that's part of our complaint, that there was no delegation. There was an abrogation. And if we go back to the Dolding case, I'm sorry, that's at paragraph 32 of the judgment. The respondents also rely upon the Dolding case. Mr. Dolding was a long-serving senior employee who applied to the post of Director of Marine and Port Services. In Dolding, the Public Service Commission was required to make a recommendation to the governor as to the appointment of the Director of Marine and Port Services. The permanent secretary for the Department of Marine and Port played a prominent role in establishing an interview panel, which in their opinion determined the most suitable candidate. The permanent secretary for the Department of Marine and Port Services provided the Public Service Commission with the interview summaries of each candidate interviewed. The Public Service Commission followed the interview panel's recommendation in recommending to the governor that Mr. John Copeland be appointed to the Marine and Ports. Mr. Dolding, as an unsuccessful candidate, sought judicial review of the PSC's recommendation on the grounds inter alia, Public Service Commission improperly delegated its function to the interview panel assembled by the permanent secretary for the Department of Marine and Ports and Services. That case is fundamentally distinguished on the simple fact that in our case, the Board of Education has the duty to make recommendations to Public Service Commission. The issue in our case was whether given that intervening layer, whether there could or should have been an interview panel given the duties of the Board of Education and given their procedural abilities to delegate, and whether that happened. That's just, it's completely different statutory format. And then just some comments in general, my lord, on my learned friends' submissions. They made a complaint that I am attacking findings of, quote, findings of fact by the learned judge. I agree with my friend's submissions about the reluctance of the Court of Appeal to interfere with findings of fact made by judges at first instance. But that caveat is confined to cases where the judge at first instance has heard the evidence of the parties and has formed an opinion on, for example, the veracity of any particular witness, or I prefer witness A over witness B. In the present case, this was all done on affidavit evidence. So this court is in just as good a position to make determinations as to findings of fact as the learned judge at first instance. Secondly, where they are making complaints is that the learned judge as to, quote, findings of fact. Some of these, for example, finding of fact that there was no improper delegation, that's just fundamentally wrong as a matter of law. So there's nothing wrong with us criticizing the learned judge at first instance for making that, for example, finding of fact, where it is fundamentally wrong, because, for example, it's contrary to the respondent's own evidence. We have other comments which are relied upon by my friend by saying, well, these are uncontradicted, these statements made by representatives of the Board of Education or by Ms. O'Brien or whoever, basically saying the procedure was fine, it was fair, we thought that there was nothing wrong with the interview panel doing it. But when you actually look at the facts where they made those statements, based on the fact that they've been told erroneously, we say, that the permanent secretary had informed the board that this was a mandatory procedure that must be followed. It was the official recruitment process. It's hard to see why, in those circumstances, members of the Board of Education would not say so. Secondly, and in any event, it is self-serving. Of course, the board thought it was fair. It would be amazing if a board member, having voted to make a recommendation of one person over another, would turn around and swear an affidavit to say it was unfair. But no matter, in my respectful submission, how hard the respondents try, they cannot get around the facts that there was no basis, statutory or otherwise, for an interview panel, because a recruitment clause simply doesn't apply. There was no compliance with committee requirements or with the provisions of Section 12 of Schedule 1. They cannot get around the fact that if the panels were not agents of the Board of Education, which is Mr. Wilson's evidence, what were they? I will make the submission. I know my Lord President doesn't care for it, but there's no consideration of the merit of of Miss Richards by the Public Service Commission.
Well, what I was saying in our discussion earlier was that it seems to me unrealistic to say that there was no consideration by the Board of Education of the merits. In relation to the Public Services Commission, the position might be different.
Well, I would, as it may come as no surprise to my Lord President, that I would say that I would rely on certainly there was no consideration properly by the Board of Education. But in any event, as my Lord President said, there was certainly no consideration by the PSC of the issue of the merit of the successful, eventually of Miss Richards, who was a successful applicant.
Right.
And finally, my Lord, only one, well, I won't get into it, as I said, I'm not going to get bogged down, but there was arguably only one Board of Education member, but possibly two. But in any event, neither had, certainly Mr. Wilson had no expertise in the issue of public school education. And at best, Miss Severn's qualifications were some, in last foray into the Bermuda public school sector was some 24, 25 years ago. So the consequences, as I've said, my Lord, of this decision, if allowed to stand, would render the Board of Education itself pointless. Because in fact, if I may say, if this procedure is upheld, where you can have so little input from qualified members of the Board of Education, despite the requirements of Schedule 1, what is to stop, theoretically, the civil service from essentially taking over the procedure entirely, having no members of the Board of Education on it? What is the magic in this case of having two members on it? If you accept the points that have been argued, you don't need any members of the Board of Education on it. And that completely obviates the purpose of the Act to have. And if you go back, just go back quickly to Section 4, the whole point of the Board of Education is to have a selection of people, a selection of individuals on the board. Look at Section 3. I skimmed over it, but perhaps it's worth just 5 persons who are representatives of schools other than senior schools in different areas of Bermuda, 2 persons, one from Berkeley Institute and one from Cedar Bridge, 4 persons from the Association of School Principals, 1 from Bermuda Public Services Union and 2 from the Bermuda Union of Teachers, and 2 persons appointed after consultation with the minister representing the business community, and 2 persons who are representative of parents of the education community appointed after consultation with any national organization representing Parent Teachers Association. That is supposed to be the board that is advising the PSC, who has no duty to have any expertise in this area. So if you're going to completely sidestep it by having this interview panel, which hasn't any statutory basis, do the job for the BOE and say that this is an acceptable procedure, you might as well not have the Act. You might as well, the expertise of the Board of Education is completely wasted. Turning to the issue of relief.
Can I just be clear,
sorry.
Diel, sorry, about, are you making the submission because the board wasn't properly constituted, its decisions are invalid?
No, I'm not saying the board, my lady. I'm saying no, I'm not querying the ability of the board at that meeting to make a decision.
Right.
What I'm saying is the interview panel,
Yes.
on which the board, they relied on nothing but the interview panel's findings. So the interview panel, having come to that conclusion, which was fundamentally flawed, it was done without the input of the experts, as the Act obviously contemplates, is flawed. So their recommendation is flawed. So too must the PSC's recommendation be flawed. So too must the governor's decision to appoint be flawed. It follows that sort of the fruit of the poisoned apple, if I can put it that way.
In effect, you're saying that the interview panel usurped the function of the board.
Yes, absolutely. How does the board conceptually make recommendations? What is the most fundamental aspect that they have to do? But just by the fact.
So the meeting of the 14th of August didn't remedy that situation. Essentially, that must be part of your argument as well.
No, because, for example, no board member with any expertise in the Bermuda system, Bermuda public school system, sat on the interview panel. The only persons from the Board of Education who actually interviewed any applicants, in fact, it's worse than that. The only people who interviewed any applicants in this entire procedure was a lawyer and arguably, I put it arguably, but a Bermuda College professor who had not been in the Bermuda public school system since 1995. Those are the only 2 people who interviewed these applicants, given the duty of the board to make recommendations. Yes, there was Mr. Rochester, a civil servant. Yes, there was HR. But again, go back to Section 12 of Schedule 1, where the purpose of having the committee is to have a majority of those members be board members.
Where the function is being delegated to the committee.
Well, no, again, we have to be careful. It wasn't delegated. I say it was abrogated.
No, I'm
Oh,
talking
sorry,
about,
Lord.
I'm talking about the requirements of section 12.
Yes.
Contemplate delegation of the functions of.
Well, it contemplates one or two things, my lord. First of all, as I say, there's an interesting word in section 12 says, 1, the board may appoint a committee for any of the purposes of the board.
And delegate.
And yeah, indeed. And so I'm sorry, agreeing with you, my lord. I'm just putting a gloss on it. So, for example, that was going to my example of saying the board could have said, we're going to perform the function of interviews, we're going to have a committee.
Yes.
And the committee will comprise of X, Y, and Z, comprising the majority. And if they wanted to include other people, they could do so, as long as the board still maintained the majority.
Right, and that would
and then
involve,
report back. But they could, you're absolutely correct. They could also have decided to say, right, we're going to have this committee, just we're going to delegate the function of making recommendations to this committee. They could have done that as well, or instead of, but they did nothing. That's the problem. And instead,
you say that what they did on the 14th didn't retroactively cure that
how could
exercise
it?
of, yes. Well, I'm just trying to clarify what you're
I'm
arguing.
sorry, Lord. Yes, I'm grateful. Thank you, Lord. It's simply the fact that you can't fix it by saying, oh, well, we're considering the recommendations of this improperly constituted panel. Because in any event, out of 5 people, the only 2 from the Board of Education, so they didn't comprise the majority anyway.
I think you're about to tell us something you've now told us about 4 times, that the only 2 people on the panel.
Sorry.
We know what you say about the lack of educational experience of even the 2 people who purported to have it.
I'll move on, my lord. Thank you. If I can deal with the issue of relief.
Yes.
Well, the application is we would say quite simple, in that there has been this failure of the entire process. We would say the appropriate application or the appropriate order would be to have this process being done in accordance with the requirements of the Act, both in relation to the Board of Education and the BSc, in order to make proper and informed recommendations to the governor. One comment I think was made by my learned friend, Mr. Horseman, in his submissions, and saying, well, time has marched on, and you know, Ms. Richards is firmly encamped in the position, and this would be wrong. Is with respect, it just doesn't deal with the problem. If the situation is that my client has not had the opportunity of having a proper and fair crack at the position, then it should be dealt with in accordance with the requirements. And the authority, the Lord, it's in our
I ask you to explain why you say that your client, apart from any other prospective candidate,
my Lord, yeah, I
did not have a fair crack.
I hold no brief, obviously, for the other excluded applicants. But as I've said already, it's indicative of the fact, the fact that they shortlisted and just automatically excluded non-Bermudians without even giving them an interview or a meet and greet or anything of that nature, is indicative of the systemic problem with this procedure, which seems to have been in place for decades. So my client certainly didn't have a fair crack at it, in my respect. And she didn't have a fair crack at it by virtue of the fact that the PSC did not consider the issue of merit, the successful applicant, and the enormous the dearth of expertise of the interview panel as far as the Board of Education is concerned. The authority I was going to refer you to is the authority of parent chief. Tab 11. And I don't intend to trouble your lordships with, I can just take your lordships to that. I'm conscious of the time. If I can ask your lordships to go to the holding, page 173, decision of Mrs. Justice Wade, first instance. Certiorari was available wherever anybody or person having the legal authority to determine questions affecting the rights of individuals and having the duty to act judicially acted in excess of legal authority. The question whether or not a statute had been complied with in the proper determination case of the applicant's office was a matter of general application. We would say obviously similar applies to hiring. Further, the question whether the court should exercise its discretion to grant leave to a senior member of the police force whose post had been unlawfully terminated by government was one of general public importance. The matter was therefore susceptible to the public law process of proceedings for judicial review. Then if I can ask your lordship to turn over the page to holding 3. Refusal to grant the relief sought would effectively validate an ultra vires act. The Public Service Commission's action in informing the applicant that his post of assistant commissioner had been abolished was based on an illegal decision of the cabinet and therefore exceeded the commission's powers. Since the governor's decision endorsed any invalid recommendation by the commission, it could not stand, and accordingly the application would be granted. If the applicant had sought reinstatement of his post, a grant of certiorari would have posed practical problems for the administration. But since he had disclaimed any interest in reinstatement, such an order would not be detrimental to good administration. Although the commissioner could have arrived at the same decision to abolish the post of assistant commissioner if he had followed the correct procedure in compliance with the statutory provisions for abolition of such a post, that did not mean that the applicant should be denied a remedy. He should have been given the opportunity to discuss his options and should have known the details. Sorry, I didn't trouble you anymore with that. Those are the same principles in my respectful submission apply here. The point about, for example, if Ms. Richards can continue in the position as acting commissioner, pending the proper interview and recommendation process. So it doesn't, the concern about this is, that Ms. Richards has been doing this job for long enough. A, doesn't get around the problem of the ultra vires issue, and B, there's an easy way to deal with that. Secondly, if your lordships are not with us on that point, then the other remedy in lieu of that would be damages, which would be quite simply the difference between the calculation of Ms. Richards' salary as it is now versus her salary would have been in the position of Commissioner of Education.
Well, that can't be right. That assumes that, well, I can tell you, it's fairly obvious. That proposition assumes that if the correct procedure had been followed, she would have been made the commissioner.
My lord, I accept that, but what that means is therefore you would apply a discount of loss of an opportunity.
So somebody has got to calculate what was her percentage chance of becoming the commissioner if a proper procedure had been followed.
Well, for example, my lord, if there were 2 candidates left,
mm-hmm.
and she's lost the opportunity, it would be a 50% reduction on damages.
I thought you wanted.
I'm not saying it's a perfect answer, my lord, but I'm trying to deal with the point that if your lordships say, well, we're just not going to grant the relief of allowing her a fair crack at the whip. Another possibility is the issue of damages. I fully accept, my lord, that there's no way of being able to accurately come to the conclusion. I've defined some, given the fact that it is
Yes,
indeed a lot.
there's a logically anterior question, which is whether or not she would be entitled to any damages at all.
Well, my lord, I would say, in the absence of the fact, if your lordships hold that she has been denied this fair opportunity and would not make a decision to say we should go through the interview process or the proper procedure again, then there must be some way of compensating.
Which cause of action had you in mind? Which cause of action had you in mind?
Sorry, my lord, been breach of statutory duty in this case, we would say.
That's a public interest point. But the closest you get is this argument for loss of opportunity.
I'm sorry, my lord, I couldn't quite hear the last.
It seems the closest you get to an argument for damages is this notional loss of opportunity.
I think that's fair, my lord. Yes, I do. I think that's fair. There's the Court of Appeal decision on the case of Ingham on that matter, which is my Lady Gloucester will be keen to know is also one of my few victories. But that's where they held that it was a beauty pageant case, and they held that the court could come to where she was improperly excluded as a finalist, that she could be compensated for by loss of an opportunity. I'm not saying it's the most elegant solution. I'm merely trying to give the court, hopefully, helpfully, options in the case that you are saying reminded not to grant the order to go through the process again.
The difficulty is that the question as to whether or not there is any cause of action for that of which you complain is quite a sizable question, which the learned judge was not invited, as I understand it, to determine. Is that right?
Well, my lord, it was, because what we cited in that issue was the McLaughlin case, which is 10. That's an unlawful dismissal case. And the court held there that he could be compensated for for the fact that he was improperly dismissed. I accept my Lord President's point that there's a contractual issue there. There's damages for essentially breach of contract, but there has to be. Well, the other issue is, my Lord, if your Lordship's not with me on that, then my respectful submission is the most obvious solution is that we go through this process again. I was merely trying to
well,
suggest,
no, wait a minute.
when I say this process, I meant the interview process, etc.
Yes, I mean, there are a number of possibilities. One, if you're right, that we go through the interview process again. The other is that we don't go through the interview process again on the grounds of time considerations and whether or not your client realistically would serve as commissioner with a permanent secretary with whom she doesn't get on. And so,
well, just pausing there, my lord. That's not a bar to anyone being appointed in a position.
Except that she said that she wouldn't.
She said that she said she had that problem, my lord. Yes.
Yes. Well, I mean, if the position is that we say the whole process must be done again, and she succeeds in the new process, the whole thing is in vain if she then says, well, actually, I don't want it because I'm not prepared to serve with the permanent secretary.
Well, no, my lord. It's the position ought to be in those circumstances. There's no reason why she shouldn't get the post. This is not a problem. My respectful submission of her making. This is a problem, unfortunately, of the permanent secretary's making.
Well, what's going to happen? She says
the permanent secretary may have to take another post somewhere else.
Gosh.
Why should my client be denied the opportunity of being Commissioner of Education through no fault of her own?
Well, no. The question is whether if she were given the post and the permanent secretary was there, she would actually take it up.
Well, I could. She would, my lord. Yes.
Right. Well, another possibility is that we don't order the process to be done again, but invite the court at first instance to consider what it hasn't so far considered, which is whether or not you have a remedy in damages for a recognizable cause of action.
Yes, Lord.
Right.
I hope, unless I can assist your lordships any further.
No, that's a very convenient moment.
Thank you, Lord.
Subject to any observations, I think we will take a 45-minute.
Mr. Duncan is trying to get our attention, I think.
Yes, Mr. Duncan. Hello.
Sorry, I'm literally in the
Mr. Duncan, I don't believe can hear us, so I'll call him and let him know that we're taking the lunch adjournment.
Well, does he? He may want to say something. Can you call him now?
Yeah, just a second.
I suspect my friend wants to know whether he's going to kick off after the break.
Yes.
We had agreed that, I think.
I had said that.
Oh, we had.
We had. I mean.
Yes, I'm sorry, your lordship did indicate that. I apologize.
No.
All right, so before going off, I'm told that they did not hear what the Lord President's comments were in respect to the damages if the case were to be considered on behalf of the appellant. So he wants to know if you could repeat that.
Can he hear me now?
They can hear you, yes.
Yes. What I had been saying was that if we were in the appellant's favor, one possible course of action might be not to order a rerun of the process, but to remit the matter to the first instance court to determine whether the claimant had a cause of action in damages, and if so, for what amount.
Seems that another question is whether we'll be able to hear Mr. Duncan when we return.
Yes, will we be able to hear Mr. Duncan?
Mr. Duncan, can you hear us now? If you can hear us, nod your head or stick up a thumb.
Seems he can't, but how will we hear him?
How do we hear him? More important.
We can't hear you. Let me call him back and they can make the submissions to the phone. Mr. Hawthorne.
We can hear you. We can hear you.
We can't hear you.
I know, and I don't know why.
So if you can put Mr. Duncan on the phone now so that he can respond to the questions my Lord President has raised.
I haven't made any questions. I'm just...
With the issue of why. We can't hear you. I know, and I don't know why. So if you can put Mr. Duncan on the phone now so that he can respond to the questions. I haven't made any questions. No, I heard the last comment my Lord President made. I just wanted to hear what it was, and he set out what an alternative option may be in the event that the ruling is in favor of the appellant. That's all I wanted to hear. Thanks.
Okay, fine. Thank you.
It may be of assistance to Mr. Duncan to, I've had this problem before in other meetings, to sign out and to sign back in again. So just a suggestion. Infamous reboot it.
Yes, quite. Okay. Quello, could you move us into a room, please?
Yeah, all right.
45 minutes.
Ourselves.
Oh,
Yeah,
can we? No.
So shall we sign out now?
I'm going to, yeah, you can sign out and we can rejoin this meeting at 12:45.
Okay, thank you.
All right.